Good evening, everyone. We'll make a start now. I'm Mark Clark. I lead the International Arbitration practice here at Akin. It's my great pleasure to welcome you all to the 2025 Akin Arbitration Lecture. The Akin Arbitration Lecture has now been running for nearly a decade, and we're delighted that Klaus Reichert SC will be presenting this evening's lecture. Klaus follows in the footsteps of several esteemed speakers, including Sherry Blair, Sir Rupert Jackson, and Dame Elizabeth Gloucester. Now, I'm sure you're all aware that Klaus is a world-renowned arbitrator. He practices out of Brick Court Chambers in London. He served as an arbitrator in more than 250 disputes under all of the leading institutional rules. He deals with disputes involving both common law and civil law and commercial and sovereign parties. His experience traverses a range of complex subject matters and industries, including the energy sector, which is where he and I have crossed paths. Now, of more relevance to this evening, Klaus is also a director of Arbitration Sciences. Arbitration Sciences is a consulting firm which helps clients with insights into how arbitrators are likely to think, feel, and make judgments about their cases. He's a co-author of this book, Arbitration, the Art and Science of Persuasion, which he co-wrote with Don Vinson, who is one of his co-directors of Arbitration Sciences. Now, this book explores the roles of psychology and persuasion in international arbitration. And this evening, in a break from more typical arbitration topics, Klaus will be exploring the enduring role of the human arbitrator and the new opportunity for science, and more specifically, behavioural science. So I've no doubt this will be a really fascinating subject. Please join me in welcoming Klaus to the lecture.
Thank you very much, Mark. So my name is Klaus Reichert. As you probably can detect, I'm an oddly sounding, oddly named Irishman, but more of that anon. I'd like to thank Mark, an old friend, and reminiscing about the time our paths crossed at a long hearing in Brussels, where I must say the tribunal certainly enjoyed itself. I'm not so sure about Mark and his opposing counsel. And thank you to Akin for honouring me with the privilege of giving this lecture. I've taken this evening as an opportunity to reflect on the role and the essential human characteristics of an arbitrator. And why am I doing this? Well, I'm doing this in an era when AI is on the tip of everybody's tongue. Everybody's thinking about it, every company, every law firm, every arbitral discourse, in fact, any discourse whatsoever, AI is sure to follow. But I thought that there is an opportunity now to stand back and reflect on the role of the arbitrator, because it's, as you will hopefully agree with me as I go through my remarks, it is still essentially a human endeavor. And as we go through my remarks as well, I believe that the arbitral process ultimately has its roots in and its evolution and manifestation as a human endeavor. I will say one thing about AI. People may think that it suddenly arrived into our lives, but as with most things in life, there's a long history that suddenly there's an overnight success. But I was trying to ascertain where AI first was mentioned. And lo and behold, almost to the day, 70 years ago, a groundbreaking proposal was presented to Dartmouth College called A Proposal for the Dartmouth Summer Research Project on Artificial Intelligence, almost 70 years ago to the day, by a man called John McCarthy. Why would I know this? Well, John McCarthy was an Irish-American, and John McCarthy's father came from exactly the same part of Ireland that I grew up in. And this is very precious to me because this single most important place in my life is where I grew up, my home spot in Ireland, despite the fact I have a German name. McCarthy won the Turing Prize in 1971. And in that paper, and I read it last night because I found it last night, 70 years ago, he identifies with incredible prescience all of the issues and challenges that AI continue to grapple with to this day. And I commend it to anybody. So if anybody really enjoys that sort of thing, I'll happily share the reference with you. Now, my remarks this evening are not going to be yet another attempt by a lawyer to add to the endless noise about AI. There's lots of hubbub about it, but what it does is it's prompted me to think about the role of the human and the human arbitrator. So we must, and please bear this in mind, the nuanced distinction between those that advocate and those that decide. So it's the latter, those that decide, will be the subject of my remarks. Now, human judgment, when adjudicating cases, has attracted the attention of the very finest legal minds. Now, I'm going to bore you with some quotations, and as with every legal lecture, there will be quotations. So the first of the very fine legal minds I'd like to reference is Lord Mustill. And as we all know, Lord Mustill was one of the giants of arbitration in this country and arbitration internationally. But it goes way back to the early 1980s when he was sitting as a first instance judge in a case called the Chrysalis. And again, for those who enjoy this sort of thing, the case reference can be supplied. He was deciding an appeal under the then arbitration law in this country from an award of somebody called Robert McCrindle. Now, you might wonder, who is Robert McCrindle? But Robert McCrindle was the preeminent advocate at the English bar in the 1960s and 70s. Don't take my word for it. That was written by Sir Louis Blom Cooper in his obituary in The Guardian some years ago. And McCrindle left the bar in England and went to work in Paris, an unusual thing for a barrister of that era. And I also know from another dearly departed colleague, Emmanuel Gaillard, that he viewed McCrindle in the highest possible regard. So you've got this interesting constellation. Lord Mustill, or Mustill J at the time, deciding on a challenge to an award rendered by Bob McCrindle. So what Mustill said is dividing the arbitrator's process of reasoning into three stages. The arbitrator ascertains the facts. This includes the making of findings of any facts which are in dispute. The arbitrator ascertains the law. Process comprises not only the identification of all material rules of statute and common law, but the identification and interpretation of the relevant parts of the contract and the identification of those facts which must be taken into account. Then 3, in light of the facts and the law so ascertained, the arbitrator reaches his decision. In some cases, and I want to emphasize the word some, the third stage will be purely mechanical. Once the law is correctly ascertained, the decision follows inevitably from the application of it to the facts found. In other instances, however, the third stage involves an element of judgment on the part of the arbitrator. There is no uniquely right answer to be derived from marrying the facts and the law, merely a choice of answers, none of which can be described as wrong. Now, anybody with any experience in this field and who's done a case more than once or twice or 10 times will know that when things go wrong and there are disputes because there is no immediately right answer. There are differing perspectives. And that essentially, as Michael Mustill said, there is no uniquely right answer. And that's what calls for human judgment. Now, I'll turn to Lord Hoffman, again, somebody well known to all of you at the very apex of the common law world. This was back in 1997, again, a case reference for those who enjoy that sort of thing. It was an appeal to the Lords on a matter of intellectual property and the appellant was seeking to overturn factual findings. Now, anybody with a modicum of basic knowledge of civil procedure knows that that's quite a tough thing to do. But Hoffman not only said it's a tough thing to do, but actually explained why. The need for appellate caution in reversing the judge's evaluation of the facts is based upon much more solid grounds than professional courtesy. It is because specific findings of fact, even by the most meticulous judge, are inherently an incomplete statement of the impression which was made upon him by the primary evidence. His express findings are always surrounded by a penumbra of imprecision as to emphasis, relative weight, minor qualification, and nuance. Or indeed, hidden in the nuance, that's my own elaboration, of which time and language do not permit exact expression, but which may play an important part in the judge's overall evaluation. I believe the word penumbra is one of the most important aspects of what Lord Hoffman had to say, and describes, in one word, the intrinsic human perception of what is unspoken. Because as we all know, computers do not live in the world of the unspoken. They live in the world of either yes or no, or 1 or 0. So, two of the leading judges of the past century have made it clear that discerning the outcome is deeply susceptible to the human condition of judgment and nuance and the unspoken. Now, I'd like to make the point in the international arena because I found a paper written in 1991 in the Northwestern Journal of International Law and Business. Obviously something one takes to bed every night for a thrilling read. But it was written by Steve Bond. And for those of you who remember him, Steve was the Secretary General of the ICC way back in the day. Again, sadly no longer with us. And he wrote an article about the international arbitrator from the perspective of the ICC International Court of Arbitration. And the quotation is really illuminating. An arbitrator must have what Professor Pierre Lalive has called the ability to judge, which implies a capacity to evaluate conflicting statements of law and of fact, and to have the wisdom, courage, and expertise to reach and render a decision in such a way that the parties, and perhaps most of all the losing party, will recognize both the essential fairness of the procedure and the futility of efforts to overturn the award or oppose its execution. So with those three quotations, those are what I would believe that some of the preeminent judges and arbitrators of the last century have had to say on the essential nature of judging. Alas, Pierre Lalive is no longer with us, but he worked into his 90s. And anyone who had the privilege of ever meeting Pierre Lalive will know that he was one of the giants of international arbitration and we are standing on his shoulders. Now, taking a slightly different perspective. And I guess one not ever used before in an international arbitration context, but I found an interview given by Pope Leo XIV in the last couple of days. And it was on a wide range of subjects. And he touched upon human relations and AI. Apologies for treading again into AI. And he said the following: our human life makes sense not because of artificial intelligence, but because of human beings and encounter, being with one another, creating relationships, and discovering each other in those relationships. Now, thinking about that, actually, as an aside, the reason he was talking about artificial intelligence was that some bright spark decided that wouldn't it be a great idea to come up with a Pope avatar. He politely declined that notion, saying that if there was one office in the world not susceptible to AI, it was probably the office of Pope. There may be others, but I think he was right in that one. But if you reflect on his words in the context of what we do in international arbitration, it resonates very strongly, and I'll hopefully make good the point. If I don't, I'm sure you'll tell me. Commercial transactions, deals, ideas which coalesce into legal documents, transactions, whatever, are the product and end result of human encounters. Someone comes up with an idea and then proposes it to a counterparty, namely another human being. Disputes don't emerge out of thin air. They are the product of human choices. Decisions, good or bad, emotive or rational, people fall out, but inanimate corporations do not fall out. Those corporations act through humans. Hearings, that cornerstone of what we do, are also human encounters. The disputing parties have their moments to explain or defend or critique. And again, that is a deeply human endeavor. And I would say it's almost unimaginable that any serious dispute today would go without a hearing. The hearing is absolutely essential, and if you look at any of the arbitral rules or statutes, if somebody demands a hearing, they are to get it. It's one of the very, very few absolute rights that one can find in arbitral laws and in the rules, because somebody wants to be heard. And by a hearing, it's not simply putting two computers beside one another or a set of avatars beside one another, but it's actually a deeply human encounter with three people sitting at one end of the room, lawyers down one side, lawyers down the other side, and the witnesses being cross-examined. And then finally, the arbitrators who preside over the hearings and read the documents and read the submissions seek to discern that which makes sense to them as a matter of the law and the facts. Now, that's not an unmoored exercise, but it's still one which anybody who's done this will tell you accords with sense and reason. Because as one of my colleagues in arbitration sciences, he's Professor Antonio Damasio, who's the professor of the Brain Institute at the University of Southern California, told me in preparation for this, computers don't care what they produce. They simply produce things. They don't care what people think of them. They don't care what they think of other people. But arbitrators, and certainly the ones I've had the privilege to sit with, they deeply care about their work product. Lawyers deeply care about the work product that's put in front of arbitrators. So that caring is an essential aspect of sense and reason. Now, having had the privilege over the last several years of working with Don Vinson, that Mark has mentioned, and I'll give you a little vignette about Don in a moment, and some of our board members, one in particular, Elizabeth Loftus, who's the world's leading authority on memory, I'm starting to appreciate the layers of human behavior and psychology which underpin all of these sentiments and observations from quite a diverse group of specialists. And it's clear to me that, and anybody who fairly thinks about this, is that arbitrators, like any decision makers, bring with them a highly complex mix of cognitive and emotive factors to their job. Those who believe that judges and arbitrators are Spock-like creatures, applying black-letter law to black-letter contracts, are misplaced in that belief. That tells you the era I was born in and started watching television. But slight aside, actually, Donald Vinson, my colleague in arbitration sciences, is viewed in the United States as the father of jury trial analysis and the jury consultancy. And he tells the story of how it all came about, because I assume many of you are aware that jury consulting is a thing in America. It all started in the late 1970s when Don, a psychology professor in California, gets a telephone call, and it goes along the following lines. Dr. Vinson, Yes. My name is David Boys. I'm an attorney at Cravath, Swain and Moore. I have a client called IBM, and we have an important trial coming up. We'd like you to construct a study as to what the jurors will be thinking and feeling during the trial. Don said to him, look, are you quite sure that I'm not in the law department? And David shot straight back at him, yes, we know who you are. You're the person we want. And Don did the very first study with a surrogate jury sitting in that hearing room during the IBM Justice Department trial, which was the single largest trial, I think, in the 20th century under the Sherman Act. And every night he gave a report to the lead attorneys at Cravath and to the General Counsel of IBM. And they were astonished at how prescient every evening the findings were, because they thought about, first, what are people feeling? What are they thinking? Completely different from the legal arguments. And that's where it all started. Don's other great claim to fame is that he accurately advised the district attorney in Los Angeles in the mid-1990s that O.J. Simpson would be acquitted if they impaneled the jury that they were proposing to impanel. I won't go any further into that story. It's actually dramatized in a number of television and movies about the O.J. Simpson trial, but that's one of his great claims to fame. Now, going back to human behavior, all human behavior has layers of emotion. Arbitrators no less so. Absolutely everything you can do as a human involves thinking. And emotion plays a hand in thinking and doing, because it's based on learning and experience. And learning and experience creates emotional memories. So emotion really affects everything that you do. So this prompts me now to introduce the science part of the title of this talk. So Don and my other partner in our firm, Andrew Clark, that many of you will remember from his time at Exxon and then on the LCIA court or the LCIA board and ICA, we have spent several years now assiduously researching with our PhDs the mix of emotive and cognitive factors associated with any arbitral decision. How these balance with each other in any given circumstance or case can vary considerably. But what is clear from our research is that both factors, emotion and cognition, are always present. And what we have actually ascertained is that in any significant arbitral decision, there's about 28 at most factors in play, generally 23 at a minimum, but it can vary up to 28. And the breakdown on our research is that 2/3 is cognitive, 1/3 is emotive. Now, people may be surprised at going, oh, this is a very sophisticated, arbitration is a very sophisticated thing, and arbitrators and arbitration counsel deal in sophisticated matters. What role does emotion have? It's the intrinsic nature of the human condition that emotion plays a part in what we do. And it's only now with some of this research that we're able to actually accurately identify the balance between the two. So by science, I mean behavioral science, the study of the human condition in all its complexities. And I'll come back to some of the points about emotion and cognition in a moment. I'd also like to touch on a second crucial issue of science, namely the sociology of tribunals. This is the unique group of 3 people sitting together to deliver one award. And how that group interacts together is not just the sum of 3 individual opinions or a vote paragraph by paragraph. You will be aware that there are certain adjudicatory bodies in the world who would take that approach. Each paragraph of a judgment is voted on by the panel of members, and each paragraph which gets a majority goes into the judgment. Or, for example, in the Supreme Court of this country or the Supreme Court of the United States, you can have concurring opinions, you can have different opinions, whereas in arbitration, it's one award. That is what the rules tell you. That is what the statutes will tell you. There is the one award. And purely speaking for myself, one of the overriding themes that I have found in my lifetime of work in this area is that there is a real driver, a real incentive for there to be one award. There's that real wish that the parties get one award. Institutions are very keen on one award. I think if you delve into the literature or the commentary, dissenting opinions or indeed concurring opinions are not necessarily viewed with hostility, but they're not viewed as the norm. Awards are the distillation and coalescing of three human views. And it can very often be the case that an award is not a document which each individual member of the tribunal would themselves have written exactly that way, but it's a collective exercise. And that sociology of tribunals does not simply engage right at the end of the hearing, but it operates and evolves right from the very beginning of a case. But it's at the hearing that it really accelerates, because that is the moment when the arbitrators are physically together for the first time. They start to probe and ask questions. And if you know what you're looking for on the transcript, you can actually identify things like alignment of language, engagement patterns, and so on. But this is all the product of the physical presence of three arbitrators together. Now, this struck me because I recalled the days of COVID when we were doing hearings remotely and the arbitrators were in three different places. And that sociology was less present, much less present, now that we're back at physical hearings. And certainly it's my experience that almost all hearings now, save in exceptional circumstances, are done back in person. People wish to see in person. And I will make one aside in relation to physical hearings, and this is slightly different from this evening's topic. But I think when it comes to the probity of evidence, particularly the probity of witnesses, the physical hearing will become incredibly important so that you see the person. And why do I say that? Again, I'm dating myself by saying, I remember when ABBA won the Eurovision with Waterloo. And anybody who's an ABBA fan will have heard of what's going on out in East London, the Avatar thing that they do. And if you go to it, you will see the highest level and most extraordinary way in which the four members of ABBA are brought back to life on a stage. It is astonishing at how realistic they are. And if one thinks about it, that level of technology will be in the hands of many people in the future. So when it comes to seeing witnesses down a video screen, arbitrators may start to think, is this really the person? No. That may be straying into the realms of fantasy, but if I was to do a prediction for the future, I think the importance of the physical hearing when it comes to probity of evidence is going to be at the forefront, and it's also the human judgment of that evidence. Now, returning to cognition and emotion, I'd like to share some specific examples of how the human condition can manifest itself as an arbitrator in the arbitral process. And you won't be surprised that I'm going to start with the concept of too much information. And what does this do to the human? Regardless of their expertise, arbitration is a very heavily cognitive process, so affect will come into play. And there's something that the scientists in the company tell me, which is called the cognitive load effect, and talking about how much information is presented in a complex international arbitration case. And one of my staff members said, and on reflection on a matter that we did, it's virtually an onslaught of information. It's actually too much. It's too complex and it's overloading the arbitrators. And here's the key thing to remember. human beings only have so much capacity to keep information within our working memory at any one time. So if you exceed that working memory capacity, mental shortcuts, biases, heuristics start coming into play in the decision-making, and they can significantly impact that decision-making. So something that we might, as lay people, and dare I say, I've started to realize that we are lay people, and the people who have PhDs and Nobel Prizes and Turing Prizes are the people with the great skills in this area. Something that we as lay people and lawyers can understand is confirmation bias. So we start in the context of this overload, searching for evidence that conforms to one's pre-existing conditions, as well as not giving much weight or disregarding non-conforming evidence that doesn't fall into line with your previous expectations. Now, there's somebody called William James, who is considered the modern father of psychology, and he described one of the first distinctions between how we think as humans, intuition or deliberation, and this foreshadowed a modern social psychological theory, the dual process theory, System 1 and System 2 thinking. System 1 is the brain's fast, automatic, intuitive, and emotional decision-making system that operates effortlessly and involuntarily, using pattern recognition and past experience to generate quick judgments. System 2 is the slow, deliberate, analytical, and logical reasoning system that requires conscious effort and attention used for complex problem solving and careful evaluation of evidence. Now, you would imagine System 2 is the one that should be utilized in international arbitration. Funny that. However, arbitrations are human and we are subject to the human experience. Thus, a number of factors can influence the use of System 1 intuitive decision-making in a case. And this, various ones could be included. Time pressure. It's interesting, the scientists will tell you that if you are put under immense time pressure, System 1 can kick in. So you need time. And in fact, as one of our surrogate arbitrators in a case told one of our researchers, I like to reflect on cases. Don't like to rush to judgment. Because if you're put under time pressure to say, I must have a decision now, that can trigger quite, without any particular deviousness or maliciousness, System 1 thinking in the human. You've got things like routine decisions, emotion, cognitive load effect, working memory constraints, information overload, witness credibility, and then some of the System 1 processes that come into play are the anchoring effect, and you'll be aware of that. And then you have numbers can influence, so the way numbers are presented. So, for example, if a claimant claims $10 million in damages and received $5 million, a similar case where a plaintiff claims $20 million would receive approximately $10.8 million. So these are the types of curious things that can happen when you're put under pressure. Arbitrators are overloaded. Long hearings, review, deliberations without breaks, information overload. That means there's an increased susceptibility to biases, and that reduces perspective taking, increased stereotyping apparently, and simplified decision strategies. So when emotion is in play, past instances can trigger emotion for future matters, and that can influence our understanding of the event. And there's a great psychological debate, and I couldn't possibly understand why this is a debate. I'm simply relating to you that there is a debate of what comes first, thinking or feeling. And there's the person who first identified this as a scientist called Lazarsfeld in 1980. But modern understanding is that they are interdependent with specific contexts triggering different processes. So ultimately, emotion affects how we make decisions, and indeed positive mood increases reliance on heuristics. Negative mood promotes systematic processing but may also increase punitive tendencies. I'd like to touch now on the area of memory. So anybody who has been paying any attention to the world of arbitration over the last 10, 12 years will have no doubt seen that there's been an awful lot of conversation within this world about memory. Now, memory is not like a video recording, but rather like one of those old filing cabinets. Every time you take a paper out and put it back in, it gets bent a little, thumbed a bit. The next time you take it out and maybe use it, you might curve a corner a bit. The next time it might go back into a different folder, and so on. Just like paper, memory is a reconstructive process where each time you recall something, you can potentially alter the original memory. And this is particularly notable for witness testimony, expert testimony, or indeed the way in which counsel might recall something in presentation. And the malleability of memory is not something that has been discovered for the world by the arbitration community in the last 10 or 15 years, but indeed in 1974 by Professor Elizabeth Loftus at the University of California, Irvine. And she is the foundational scholar in the area of memory. And we are privileged in Arbitration Sciences that she's on our advisory board. But it's interesting when I've had the privilege to meet her and explain to her what's been going on arbitration, she finds that what we've been talking about recently is really only the most basic elements of memory study. And all of this has been done before. In ways, there's almost nothing new in the world. So the analysis and scientific research into memory has already been done extensively by the science community. Dare I say, like many aspects of the legal world, we come to things a little later on. But when we come to them with a degree of style. There's a lovely line in that study which it showed participants car crash videos and asked them to estimate the speeds of the cars, and then they used different verbs like hit or smashed. When verbs like smashed were used instead of hit, people reported higher speeds and even remembered seeing broken glass that wasn't there. So events in arbitration often happen years before the hearing is actually given, so the risk of false memory is higher, potentially affecting witness credibility. And it is risked further on how attorneys ask questions of the witnesses, and indeed can affect the attorneys in how what they remember is relevant during the course of a cross-examination. I'd like to talk very briefly now about going back to the sociology point. How all of these come together when you take into considerations of the group decision-making or the sociology of the tribunal. There's something called group polarization, the phenomenon where a group's attitudes become more extreme after group discussion than they were before. And that's a study from the 1970s. Myers and Lamb. Again, for those who enjoy this sort of thing, I'll happily supply the references. Then there's something which I really enjoy. It's called the risky shift. It sounds potentially more enjoyable than it actually is, but it's a form of group polarization where a group's collective decision is riskier than the decisions the individual members would have made on their own. It's a sort of each person gives cover to the other. They form a protective shield about each other. And then there's hierarchy. And hierarchy affects where more senior judges have more decision-making power. And there are studies in the United States of 20,000 judges in relation to that. So people can risk isolation and so on and so forth. Now, I'd like to conclude with how science can assist and the opportunity for science. And what I'm talking about now is not AI, as I think I've made clear, but it's some of the research and the work that we've been doing in Arbitration Sciences. And one of the things that we want to achieve is to detect and discern the existence of these factors, the factors that I've been discussing in outline, for a particular case at hand, for a particular client, the various phenomenon and how they can be identified and then deployed effectively for the presentation of your case. What are the likely results of these efforts that you would make? I can give you perhaps two examples of the type of work that we've done. First one is where we would, what we call our marquee product. And in a way, it's very similar, but inspired by what Don did for IBM 50 years ago. We utilize, on a case-by-case basis, a panel of 5, not 3, 5 surrogate arbitrators that we would choose specifically for the case at hand. So, for example, if it's a civilian case or an investor state case or a common law case, we will carefully choose, and this is the company's choice, experienced arbitrators who have a real feel for this area, and we will retain them, and we will then provide them not just with the materials in the case at any particular stage in the case. The one that certainly has been most popular is in the run-up to the hearing, the preparation for the hearing, where the materials are filed and ready to go, and you're ready to go for the hearing. So people want to ascertain, where are we from a psychological, persuasive, behavioral point of view? They don't look to us for legal advice. We're not a legal consultancy, and we're quite clear about that. We then extract data from our surrogates. And the extraction of data is not simply a couple of nice questions or gut instincts from our surrogates, but an immensely complex several-day process where we have detailed questionnaires, we're using Qualtrics, we have the group discussion. This is where it is really quite fascinating, because we put our surrogates together and they debate the issues in the case, and we record every single thing that they have to say. We put that down and we then extract their words, and I'll come back to why we do that in a moment. So we take away thousands of data points from that, and then our PhD analysts, whether they're psychologists or statisticians, we analyze the data and we present our findings to show where the strengths and weaknesses from a human point of view, the behavioral point of view, are in the case as articulated up to that time. Why do we take an interest in the words as used during the surrogates' deliberations? Because all words can tell you much about their content, not just the dictionary definition, but words can divide into cognitive words and emotive words, sentiment. And you can actually, and we can identify with great precision exactly where the sentiment is amongst our surrogates for any aspect of a case. So, for example, you may have a very strong case on liability, but the sentiment may be against you. The tribunal may not like you very much. But we can identify exactly where that sentiment is located. And when you're dealing with, for example, you're a claimant and you're looking for an award of damages, as we all know, there's much greater discretion when it comes to the awarding of damages. The fair win theory, I think you will find in many legal systems. And if you know going into a hearing where the sentiment is, and you know that I may have a strong case in liability, but for various reasons they don't like us, you can correct your course. You can preempt that as long as you know. That's one product. The one which we have just developed and which and it's inspired by the sentiment product is research into the transcripts. It's astonishing what a transcript of the hearing will tell you by the words. The words themselves are quite fascinating because you can actually identify over the course of several days things like alignment between the language used by arbitrators, whether or not one arbitrator is, they may not believe that they're doing so, is aligning in the way that they ask questions, is aligning in language. And you need to know where to look on this. I wouldn't know how to look at this. I mean, I'm an Irish barrister. I started where we had one fax machine in the forecourts. But if you know where to look, you can identify all sorts of things, including the various ways in which witnesses answer questions. And there are very specific psychological ways in which humans respond to questioning. And you can categorize those with great precision, again, if you know what you're doing. So this is what we are doing now in the post-hearing phase. We're supplied with the transcripts by a client, and we set it. Now, it is a combination of PhDs and AI, because AI is very good. AI is excellent. You know, if you say you've got to work all night, that's not a problem. You don't have to have a quick word with the HR department. You can put it to work. Anyway, those are just some of the thoughts where I would like to share with you this evening. But I know that amongst some of you, you might be asking the question, and you probably will ask the question, what of AI? And I thought I may as well deal with this now, because of course it's a big topic and everybody's talking about AI and arbitration, AI and arbitrators. Frankly speaking, if you were to divide the world into those who represent and those who decide, in the world of representation, that debate is already over. AI is used everywhere. And look, I know from many firms and many lawyers and many clients that AI is embedded not just into the legal service, but it's part and parcel of how people go about the daily work of a company. And speaking for myself, as long as that which is presented to arbitrators is ethically sound and factually rigorous, if AI is used, so be it. Whether or not it's actually persuasive is a different matter entirely. Because as we all know, an AI document or AI produced document can actually be quite dead in its field. You read it and there's nothing to it. Now, again, there's a question of culture. I come from Southwest Ireland, County Kerry, which is the most precious place in the world to me. And lyricism of language is truly important. There are other parts of the world where I've had the privilege just to sit and work where that type of language would not be appreciated. But ultimately, whether or not AI on the representation side is of assistance, that remains to be seen. But I don't personally have any problem with that whatsoever, as long as it's accurate and ethical. There is a debate at the moment, and I won't stray too much into it, but for those of you, again, who enjoy this sort of thing, there's actually a pending case in the federal court in Los Angeles about whether or not AI was used by an arbitrator in the rendering of a domestic AAA award. And that will make its way, no doubt, through the courts. And indeed, the use of AI by arbitrators may be something for courts to decide. Whether they say it's right or wrong, who knows? But I think the more interesting question is whether or not AI will replace human arbitrators. I think that's, some people believe that it will, some people believe that it won't. Nobody can actually tell that with any precision. If I could tell you that, frankly, I wouldn't be standing here. I would be heading back to Ireland to go to Punchestown races with a very large bag of cash to predict each winner on each race. But I'm not going to do that because we don't have that level of prescience. But interestingly, the points that John McCarthy's proposals 70 years ago made to Dartmouth remain good because he references one of the difficulties about replicating the human condition with machines is the element of randomness. And humans are random people. Random things can happen. Yeah. I picked a black tie this evening to come here. I could have picked a red tie. It just was an instinctive choice there and then. It's not because I'm a gloomy person. Possibly I am, but I leave that for you to judge. But I think what may happen in the future is, and this is the best prediction that I can make, is there may be a choice of you can have your arbitration decided by natural intelligence or by artificial intelligence. I don't believe one will supplant the other. I think there will be a choice. So there may be in the future, when you look at the standard form requests for arbitration at the institutions, there may be a box at the bottom which says, please tick the box. Do you wish to go down our AI arbitrator route or our human arbitrator route? And those who pick it, there's your choice. But again, interestingly, that would be a human choice. So with that, I shall cease boring you senseless because I know I'm standing in the way of entertainment, frivolity, and thank you so much for your attention.
Klaus, from Akin and all attending, a huge thank you. A wonderful topic, a genuinely thought-provoking topic. Both your book and today's lecture are a substantial contribution to our practice. If counsel were professional athletes, and I'll reserve comment on that, but if we were, I have no doubt that we would be drilled on the potential gains and competitive advantage of understanding a number of the topics that you covered tonight. You have not only challenged us to be more thoughtful and intentional in our dealings with decision makers, but through the latter chapters of your book, you've given us a roadmap to be so, and that is really commendable. And we thank you for a great 2025 Akin Arbitration Lecture.